Mr. Richardson, you ready
Thank
for
you.
cross-examination?
Yes, I am. May it please the court. Thank you. Good afternoon, sir.
Before we do that, state's here, defense is here, and the defendant, Mr. Raj, is here. Okay, yes.
Good afternoon, sir.
Good afternoon to you.
We met before.
We have.
It was when we took your deposition back in, I think, January of this year. Is that correct? Right.
I took my deposition. When it was, I'm not quite sure.
Okay, right after the first of the year. And let's go back to what your assignment was in this case. You were retained by the Office of the State Attorney back in, I believe, the spring of 2016 to answer this question: whether Officer Nouman Raja's actions during the specific time period of his approach to Corey Jones' disabled vehicle to when backup personnel arrived at the scene of the shooting were in conformance with generally accepted police practices, correct?
Correct.
Now, the time period of his approach to the disabled vehicle until the time period that backup personnel arrived included the shooting, didn't it?
It did.
The very first report that you rendered in this case was in May of 2016, correct?
Correct.
All right. And in that report, you offered no opinion whatsoever with regard to the question of whether or not the shooting was justifiable, did you?
I did not.
As a matter of fact, you had never even been asked to offer an opinion on that question, had you?
I was not asked.
So the critical thing in this case, we're talking about an attempted murder and manslaughter case. Whether or not the shooting was justified, you were never asked to offer an opinion on that, correct?
Up to that point, yeah, no, I was not.
Up to that point being what, January of 2018?
For my deposition, correct?
Okay. So almost a year after you were retained, you had never been asked to offer an opinion on that subject matter, correct?
Correct.
And when you sat for your deposition, you told us, I don't have an opinion on that.
That is correct.
So, once again, we are talking about a manslaughter and attempted murder case, and the crucial act is the shooting, and you were neither asked to offer an opinion and didn't have an opinion up until the time that you were deposed in January 2018, correct?
That is correct, sir.
As a matter of fact, if you'll recall correctly, when you and I and Mr. Fernandez, Ms. Ellis, Mr. Lubin, Mr. King were all gathered together in the State Attorney's office to take your deposition in January of 2018, I asked you whether or not you'd ever been asked to offer an opinion on that, and you said, I feel like a deer in the headlight.
I did say that, sir.
And the reason that you said that was because the thought had never occurred to you that that was what you were going to be asked about, right?
No, sir.
All right, but that's what you said.
It is what I said.
Okay.
That just wasn't the reason I said it.
Okay. Well, you felt like a deer in the headlight about some question I asked you, didn't you?
I did.
And it had to do with whether or not you had an opinion about the shooting, didn't it?
It did, sir.
Okay. All right. So that is an opinion arrived at later. Yes?
The opinion was relayed later. Just because someone hasn't asked me to opine doesn't mean that I don't form opinions.
Well, you said you didn't have one.
No, you asked me if I had been asked to give one. I did not give one. I did not give one to you. You asked me. I felt like a deer in the headlights. I had not opined as to the justifiable use of force in that case until you asked me at the deposition.
Okay. From the date of your retention until the time that somebody asked you that question, you hadn't opined about it.
I hadn't opined about it, correct.
Okay, fair enough. All right. Now, let's go back to when you were discussing the approach to the vehicle. You would agree with me, wouldn't you, that Officer Raja's decision to approach the vehicle or to check out the vehicle was not unreasonable, would you?
I will agree that it's not unreasonable.
As a matter of fact, you heard the radio traffic where he told his supervisor about the vehicle on the side of the road and said, I'm going to check it out, yes?
Yes?
And his supervisor responded 10-4, yes?
Yes.
And that means, okay, I got it, I hear you, right?
Yes, it does.
Okay, so he was authorized to do that,
Correct.
yes?
Yes.
Okay.
Your Honor, I just raised an objection that the defense is saying that I can't get into the orders by this defendant's sergeant as it relates to plainclothes, then they shouldn't be able to get into orders by any other supervisors whether or not to check out the vehicle. I just want to put that on the record.
It wasn't an order, it was an authorization. Has nothing to do with orders being given about what to do, what to wear.
It's a
Talking,
distinction without a difference to me.
Okay, well, I'm going to determine whether or not I'm going to consider the supervisor's orders, authorizations, and authority that night. So you can ask the question. Go ahead.
thank you.
You can ask.
He was authorized to do that, wasn't he?
Yes.
Now, you criticize Officer Raja for driving up the wrong way on the off-ramp coming southbound on I-95 to PGA Boulevard, right?
I did.
Okay. You realize that the only other option that he had in order to get there, to drive there, would have been to have driven approximately 8 miles north on I-95 to Donald Ross Road, make a U-turn, come back down to the site of the vehicle, correct?
Yes, I am aware of that. I know that's the next exit. There appears to be a turnaround halfway, but I never observed it, so I don't know if that turnaround is available for authorized vehicles or not.
Okay. Nevertheless, if he had decided to do that, it would have taken time away from what he was authorized to do, which was to check out the vehicle.
It would have taken longer for him to check out the vehicle.
Correct. Now, you also say that you criticize Officer Raja for pulling his vehicle where he pulled it, correct?
Correct?
All right. Now, you understand from all of the evidence in the case that as Officer Raja was pulling his vehicle to where he pulled it, what caused him to stop his vehicle was Mr. Jones getting out of his vehicle, which was a complete surprise to Mr. Raja, correct?
I'm going to object. That's not the only evidence that's been presented, Your Honor. Just a mischaracterization of the evidence by.
That's not the only evidence that's been presented, but you can ask the question about the timing of jumping out.
Isn't it your understanding of the evidence that Mr. Raja stopped his vehicle in response to Mr. Jones getting out of his vehicle?
Yes.
When a subject gets out of a vehicle and a police officer is in his vehicle, isn't that putting the police officer in a vulnerable position, sitting inside of his vehicle?
Yes.
So a natural response to Mr. Jones getting out of his vehicle would be for Officer Raja to get out of his vehicle.
Yes.
As a matter of fact, when police officers stop individuals on the roadway for speeding or whatever it is, a traffic violation, they are told to remain in the vehicle, correct?
It is situation specific, but as a general rule, yes.
All right. And isn't it your experience that if people who are stopped get out of their vehicle, that officers tell them, get back in your vehicle?
Once again, it is situation specific, but as a general rule, yes.
And one of the reasons for that is officer safety.
Yes.
Because a person outside of a vehicle and an officer inside of a vehicle, the officer is in what is called the fatal funnel, correct?
It's one of the reasons. The other reason is to protect the individual that got out of the vehicle, the citizen.
All right. Well, let's talk about this fatal funnel for a second. The officer sitting in the vehicle, not getting out of the vehicle, and there's a subject outside of the vehicle, the officer is now in his vehicle, and you've heard the term used before, tomb or womb, correct?
You know, I have never heard that term. I apologize.
In all of your 38 years, you've
I have
never
not heard
that?
it, sir.
Okay, first time was today?
First time was today.
Okay. You've heard the term fatal funnel.
I have heard of the term fatal funnel.
Okay, and fatal funnel basically means that the subject is outside and can travel a distance and can walk in a range, but the officer is in one spot, correct?
Fatal funnel, as I understand it, means that the officer is within that funnel and the person may have clear avenue to attack the officer from that funnel.
So that's a reason that
You get mobile.
the officer gets mobile.
Yes.
Okay. So as not to be so vulnerable.
Correct.
Okay. Now, you have offered an opinion that Officer Raja failed to follow accepted police practices because he failed to identify himself, correct?
Yes.
All right. Let me ask you to assume, well, let me back up for a second. You've heard the audio from the AT&T roadside assistance call, correct?
Yes, sir.
Okay. As a matter of fact, you have attempted to recite that interchange between Officer Raja and Mr. Jones in your report, correct?
I tried to infer what was said from the response of Mr. Jones to whatever was said.
Okay. The first thing I want to do is if you would turn to page 3 of your report, your very first report, sir.
Yes, sir.
Okay. Paragraph 11.
Yes, sir.
During this paragraph, you're talking about the phone call being recorded by Allied Dispatch, which was actually the outfit that was recording it, even though AT&T Roadside Assistant was the company that was called. You understand that, correct?
I do.
Okay. And then you said in your report, 9 to 10 seconds after Corey Jones opened his driver's door, the following exchange took place. And the first thing you say is, CJ, no, I'm good, yeah, I'm good. Correct? That's what you put there, right?
That is correct, sir.
That's not what happened, is it? That's not the very first thing that was said that you can hear on the audio, is it?
No, that is the first thing that I determined to be human voices speaking.
You did not hear prior to Mr. Jones saying, no, I'm good, yeah, I'm good, huh?
I'm pretty sure this is what I heard, what I put in my report. In the deposition, you asked me if I heard noise, and I said, yes, I did hear a noise prior to that, but I was unable to discern what it was.
Well, are you telling us, sir, that you have listened, I think you said you've listened to that more times than you care to, but that you have listened to that and it is your determination, as recounted in your report here, that the very first human voice you hear is, no, I'm good, yeah, I'm good?
No, sir, what I said in the report was, you opened the door and the following exchange took place. I never said anything about being the very first thing, et cetera. And you asked me that during the deposition as to what I heard, and I said there was some type of noise. If he said "ha" in there, I did not put it in this report. I just put what I said here. The following exchange took place, okay? And that's what I put in the report. It's accurate.
All right. So are you acknowledging now that in the AT&T roadside assistance call, you do hear a human voice say, huh? Huh? Question mark?
I'd have to listen to it again, sir. I cannot tell you.
How many times have you listened to it?
Oh, like I said, more times than I care. Probably half a dozen times.
Half a dozen times, and you haven't picked that up?
Thanks, Sonia.
Is that no?
Oh, I'm sorry, sir. I don't remember it. I apologize.
Okay. Well, let's assume for a second that there is the word huh.
Okay?
Okay? As a matter of fact, do you have your deposition? A
I do
copy
not,
of it?
sir.
Okay, I'll be happy to provide a copy. May I approach the witness, Your Honor?
Thank you, sir.
you would turn to page 41, line 19. Take all the time you need to review it, and let me know when you're done.
Line 19? And how far would you like me to review, sir?
Page 42, line 3.
Okay.
Now, you in fact inferred, based upon your listening to the audio, that Mr. Jones' response, no, I'm good, yeah, I'm good, that the reasonable inference was that something was said by Mr. Raja prior to that, correct?
I believe so.
So let's assume, and you've offered an opinion that one of the failures in this case by Officer Raja is his failure to identify himself, correct?
Correct.
All right. But now you're agreeing with me that there is something that is said before Mr. Jones responds,
I'm inferring that, yes.
okay? And that's a reasonable inference, isn't it?
I said so. I
Okay.
believe so.
All right. And so it would be a reasonable inference. I mean, and you, because of the distance between the cell phone and where Mr. Raja is, you can't tell what exactly was said.
Objection, Your Honor, outside this witness's area of expertise.
I'll rephrase the question.
Okay.
You hear a sound, correct?
Correct?
But you cannot tell exactly what is said, correct?
I don't even know if it's a human voice.
Okay. But assume that he identified himself as a police officer. Make that assumption for the purposes of this question. If you assume that he identified himself as a police officer, your criticism of him failing to identify himself as a police officer is no longer valid, correct?
If you were to assume that he identified himself as a police officer, then my criticism of that would no longer be valid.
One additional step on this identification. I think you testified in direct examination that one of the things that you tell your officers is to wear a vest, correct?
Correct.
As a matter of fact, I even think you said, wear the vest underneath the shirt.
Sure.
Well, if you're wearing a shirt over a vest, and the vest says police on it,
I'm sorry, say that
I'll
again.
start
sir.
all over again, all right?
Start
If
again.
you're wearing a vest underneath a shirt, and the vest says police on it, but the shirt is over the vest, you can't see police anymore, can you?
Yeah, not all vests carry police on them.
Right, but what you're saying is, you tell your officers to wear a vest and then put a shirt on over it.
I told my officers to wear a vest for officer safety. They're in plain clothes, they wear a vest, you put a T-shirt over it, you also wear your police indicia. You wear a badge or your police ID, and I usually have a raid coat available.
Well, as soon as Officer Raja sees Mr. Jones jump out of the vehicle, are you telling us,
Objection, Your Honor, it's a mischaracterization. He jumps out of the vehicle.
I'll rephrase it, as soon as Mr. Raja sees Mr. Jones get out of the vehicle, if Mr. Raja does not have his vest on at that time, are you telling us that it would have been reasonable and required for him to put his vest on at that time, while in the van?
No, I said he should have his vest on prior to doing that.
Right? If he didn't have his vest on at the time, understand? If he didn't have his vest on at the time, would it be reasonable or unreasonable for him, once he sees Mr. Jones get out of the vehicle, to then put the vest on?
I think it would be unreasonable.
Right. Because back to what we were talking about before, the officer needs to get out of the vehicle for safety purposes. Correct?
Correct.
You, I think you told us before that you are not an expert in fight or flight. Is that correct?
No, I'm not,
You're not? Yet you were offering opinions about it earlier today,
based on my own experience, sir,
right? But not as an expert.
not as an expert.
You're also not an expert in something that is called perceptual distortion, are you?
No, sir, I'm not.
As a matter of fact, I think when we took your deposition, you'd never even heard of the phrase. Is that right?
I don't, I've heard perceptual distortion before. I don't think.
Could you have defined it then?
Yeah, I think I could.
What is it?
Right now?
Yes.
It's an individual perceives things in a distorted manner. How does that sound?
Okay. Perceives things and then relays things in a distorted
Yeah,
manner,
you-
correct?
When a person sees something, it's encoded, okay? And when they encode something, depending on the stress levels that they have, and this is just based on items I've read about this, that it can affect how you encode information. And then how you encode it and how you relay it at a later date may be different, okay?
Right.
So,
And one of the reasons for that perceptual distortion would be a sudden event,
acute stress.
acute stress,
It's called acute stress syndrome.
okay? Acute stress syndrome. And one of the, you would agree with me, wouldn't you, that an officer, I'm sorry?
That would depend.
Well, let me finish the question, we'll see, okay? You would agree with me, wouldn't you, that because of the fact that an officer is sitting in a vulnerable manner in his vehicle, when he sees somebody else get out of another vehicle, that can very well cause an acute stress reaction.
Your Honor, this is obviously outside the area of expertise. We're getting into psychology and physiology associated.
If he has familiarity with it, let me hear the question. If he can answer it, I might allow it. Let's hear the rest of the question.
I had finished it, but I'll rephrase it.
I can answer it.
Are you able
You
to?
can answer it? Okay.
The answer is no. I would not, if someone just gets out of a car, I don't go into acute stress syndrome and he gets out of his car. Oh, that car's now occupied. Okay.
So you're saying that the reaction of the police officer, I thought you said earlier that the reaction of the police officer is to get out of his vehicle because of the vulnerability he's in.
He said for officer safety, and in answer to your question is when someone gets out of the car, you get out of the car. And you usually direct the individual, sir, would you mind getting back into your car for your safety and mine?
And you're saying that in and of itself would not cause this acute stress reaction?
No.
All right. What about when a gun is pointed in your face?
Yes.
Okay. Now, you would agree, wouldn't you, that when a gun is pointed in someone's face, they have the right to defend themselves with deadly force, correct?
Yes.
Now,
And I'm going to qualify that.
go right ahead.
If the individual causes that gun to be put into his face and creates a situation which causes a normal citizen who had no propensity to pick up a gun and point it at a person's face, but that person thinks he's defending himself, then I'm not so sure that person should benefit from it. Do you understand what I'm saying?
Well, let me phrase it a different way.
Okay.
Regardless of what caused the situation, in your opinion, you think that Officer Raja's action caused the situation. But at the point in time when the gun is put in his face, he has the right to defend himself, does he not? Or are you saying that because of the errors that
That a gun was pointed in his face.
yes, I am.
Okay. I'm
Right.
not.
You're not? Okay. Well, let me just finish my question, okay? First is that assuming that the gun is pointed in his face, he has the right to defend himself with deadly force. You agree with that, correct?
As I said, I qualify that. There are some situations when that would be accurate, and there are other situations when it would not be. And you're asking me to assume that a gun was pointed in his face, and I'm unwilling to assume that, sir.
Okay? Now, you heard Officer Raja in his walkthrough tell the investigators that a gun, in fact, was pointed at him, correct?
I sure did.
Okay. And you heard him tell the investigators that he was very specific about what he saw on the end of the barrel of that gun, correct?
I heard him say that there was a laser in it, yep.
A laser. What he said was a laser, a flickering red laser, correct?
I'll assume you're correct, yes.
Okay? Now, have you ever seen, I believe when we took your deposition, I asked you whether or not you had ever seen photographs that had been taken by investigators from the Palm Beach County Sheriff's Office and the Palm Beach County State Attorney's Office a week to 2 weeks after the incident, correct?
And I said no, but I was incorrect in my deposition on that and did correct it during the errata sheet.
Okay, let's go over that a little bit more carefully.
Sure.
Okay. You do know that approximately 2 weeks after the incident, that investigators from PBSO and the State Attorney's Office went out to the scene in the early morning hours and, utilizing the same gun that Corey Jones had, pointed it in the direction of a videographer who was videotaping what was going on, correct?
Yes.
All right. And also taking still photographs of what was going on, right? And when your deposition was taken, you initially said, no, I don't think I've ever seen those photographs, correct?
And Judge, I'm going to object to this. His actual deposition, based on the errata sheet that he provided, is what is written on that errata sheet. That is incorporated into being his actual deposition.
And
For Mr. Richardson to try to impeach him and say that he said something different and changed it, that's improper.
Isn't that the purpose of the errata sheet?
I'll get.
It's incorporated as that original statement. So his original statement, because of that errata sheet, is he did see those pictures.
Okay, I will go with that. I will go with that, Your Honor. Your errata sheet, your actual testimony then, per your errata sheet, was that you had seen those photographs, correct?
Some of them, yes.
Okay. Now, you had been provided with a number of photographs for your deposition, correct? Or for your analysis in this case.
Correct.
And all those photographs were placed on a flash drive, correct?
I believe we had some discussion on this, whether I got them through Dropbox or a flash drive, but I did receive them.
But they were placed on a flash drive, and then they were given to us at the time of the deposition, correct?
Oh, yes.
Okay.
Whatever you,
So all the photographs that you received prior to giving your deposition were on that flash drive, correct?
to the best of my knowledge, sir.
Sure.
I'm handing you a flash drive which says on it, Defendant's Exhibit 2, Libby 1318. Do you recognize that as the flash drive that you gave us at the time of your deposition of January 3rd, 2018?
I recognize it as an exhibit, but I believe it came from the state attorney's office. That's not my flash drive.
Okay, but do you recognize it as an exhibit that was given to us at your deposition?
Yes, yes, I do.
All right, and as a matter of fact, as we went through your deposition, we talked about everything that was on your flash drive, correct?
Correct,
Which you brought to the deposition,
which I gave to the state attorney's office.
and copied onto this flash drive.
My hopes are I didn't copy it.
Okay. Nay, I'm going to introduce this as evidence, Your Honor, as the next defense exhibit.
Steve?
I'm sorry I didn't hear that, Your Honor.
He wants
Introduce this evidence as the next defense exhibit.
If I can see that again, please.
Sure. Can I get another water, do you think? If I,
Sure. Do you have any more
I
water,
don't.
or you need some water?
Christine, do you have another water? Or can you get me one?
Yeah.
Awesome, thank you.
Do you want to,
And Your Honor, I haven't seen the contents.
right, so that's,
So I understand it appears to be Exhibit 2 from the deposition, although I wasn't attached to the deposition. It's in the same writing, same date.
do you have a means to look at it right now, a computer that you can take a look at the contents?
I don't know the purpose of this, but
Okay.
is this something I'm supposed to be looking for? Because I'm sure, I know there's a lot of documents on that. If it's the thumb drive, I'm sure it is.
Mr.
There's a lot of
Richardson?
documents.
What's on it are the photographs that he said that he looked at before his deposition. And what's not on it are photographs from that demonstration, the light reflectivity test.
I
Okay.
don't think it needs to be introduced in order to do that.
No, you,
I don't know what's on the thumb drive. I'm sure that they haven't put anything additional on the thumb drive since the time it was put in as exhibit. I haven't seen what's on it.
Okay. Hold on one moment, sir. So, why don't, I mean, if you want to take a moment and look at it before, in between at some point, and you can provisionally admit it, and if you're okay with it, or we can talk about it at a later date, are you going to show it to the witness right now? The contents?
Yes.
Okay. Then let's approach for a moment, please. Okay. Thank you, Mr. Richardson.
May we have a moment, Your Honor?
Sure,
Thank you for your indulgence, Your Honor.
sure.
All right, let me go back to the flash drive for a second, Mr. Libby. I'm holding in my hand Defendant's Exhibit Number 2 at your deposition of January 3, 2018. And the question was, did you provide, let me ask this question, did you provide to the state and to us at that deposition everything that you reviewed prior to giving your deposition?
yes,
Would it surprise you, sir, that the photographs that you say you saw about the red flickering, the light reflectivity test are not on this flash drive?
can I clarify, sir?
Certainly.
When I left LJ, I copied my entire file onto a thumb drive. On that was emails between prosecution and myself, et cetera, which are privileged communication. I took the thumb drive, and the day before the deposition, I met with the state attorney's office, and they took the thumb drive to go through it to make sure that there wasn't anything that was privileged on the thumb drive. They then put it on their thumb drive to give at the deposition to the defense. At the deposition, I was asked, and I said, I don't remember seeing those photos. And that was my original testimony, was it not? And then after the deposition, I was informed by the state attorney's office that some of those photos were in the PowerPoint that the FBI provided. Oh, well, I didn't know that. So I did an errata sheet saying, yes, I saw photos of that, okay, and submitted it. I don't know whether I've seen all the photos as to the laser. I can't tell you that.
Okay,
Can we approach, Your Honor?
sure.
Mr. Libby, did you have an opportunity to review the video of that light reflectivity test from which those still photographs were taken?
I don't know. I can't.
You don't know?
No, I can't tell you, sir. Doesn't ring a bell.
Okay. Now, let's talk about, we were talking about, I asked you a question, if someone has a gun pointed at them, do they have the right to defend themselves with deadly force? And you said it depends upon the circumstances, right?
Yes, sir.
Okay. Now, are you familiar with Florida Statute 776.041?
Stand your ground?
No, use or threatened use of force by aggressor.
No, sir.
All right, let me read it to you. The justification described in the preceding sections of this chapter is not available to a person who, 1, is attempting to committing, or escaping after the commission of a forcible felony, or 2, initially provokes the use or threatened use of force against himself or herself unless, A, such force or threat of force is so great that the person reasonably believes that he or she is in imminent danger of death or great bodily harm, and that he or she has exhausted every reasonable means to escape such danger, other than the use or threatened use of force, which is likely to cause death or great bodily harm to the assailant, or subsection B, which I would submit is not applicable. I'll read it if counsel wants me to.
I would, Your Honor.
You would? Yes? All right, B. In good faith, the person withdraws from physical conduct with the assailant and indicates clearly to the assailant that he or she desires to withdraw and terminate the use or threatened use of force, but the assailant continues or resumes the use or threatened use of force. Are you familiar? You're not familiar with that statute?
No, sir.
Okay. Are you familiar with the case of Martinez versus State, cited at 981 Southern 2nd 449, Florida Supreme Court case from 2008?
Not off the top of my head, sir.
Are you familiar? Okay. So you are not then familiar with the fact that the Florida Supreme Court has interpreted the words initially provoke in section 776.041 to mean initiate an assault. You're not familiar with that, are you?
No, sir.
Now, is it your opinion that Mr. Raja attempted to was committing or escaping after the commission of a forcible felony?
Mr. Raja
Yes.
was attempting to, no, I don't understand your question. sir.
I'll start it. It's very simple. Is it your opinion that Mr. Raja was, at the time, was attempting to committing or escaping?
I object, Your Honor. I understand that the witness has a law degree, but defense is asking to make legal interpretation that's within the purview of the court. He's given his expert opinion on whether or not use of force is justifiable, but as far as legal interpretation and case law analysis on the spot with nothing to prepare for it. It's outside of what he's here in his area of expertise.
Okay, but there has been some discussion about threat or some initial threat. So, I mean, case law, you know, I don't think that that's appropriate to ask him about case law because I don't think he's going to be familiar. You can ask him about in terms of an initial aggressor, and if
Okay.
you believe that there was an initial aggressor in this, but
As-
the ultimate determination will rest with me.
Yes, Your Honor, as defined by Florida law.
Right.
Okay. So I think my first question was, well, I'll rephrase the question. You don't believe that Mr. Raja was committing a forcible felony at the time that he approached Mr. Jones?
No, I don't think so.
Okay. And Mr. Raja was not initiating an assault on Mr. Let me ask the question. Is it your opinion, sir, that Mr. Raja was initiating an assault on Mr. Jones at the time that he stepped out of the vehicle?
I don't know what Corey Jones perceived. Now, I assume as assault as compared to a battery, taking my Massachusetts law enforcement training in, as an assault is a present ability to attack somebody, okay? When he rapidly ran in front of the car and came right at him with an accusatory, really, I don't know what was in Mr. Jones's mind, okay? Whether Mr. Jones thought he was imminent assault was present. I can't tell you that.
Okay, so therefore, you do not have evidence to indicate that Mr. Raja was committing an assault.
Other than the rapid approach to the vehicle, no.
Okay?
Well, you know, coupled with driving up the one-way on a road in a vehicle that was undistinguishable and pulling and blocking the individual's car in and then jumping out and running out, I think there's factors there that could be taken into consideration.
So therefore, you think then that those factors would have justified would have justified the filing of an assault charge against Mr. Raja for those actions?
No, in Florida, I'm pretty sure, and correct me if I'm wrong, because it's been a while, I've been gone for 4 years, isn't an assault an actual, you have to have a touching?
No, it's not.
I don't know.
The defendant's charged with manslaughter and attempted murder.
I have to say at this point, Mr. Richardson, I'm going to sustain the objection. I don't think we want to go down these legal conclusions, this road. If you want to ask him about the initial aggressor, or if you believe, but not about anything in terms of calling for a legal conclusion.
Yes, Your Honor, most respectfully, initial aggressor is part of the legal analysis. So-
I understand, but I think that's part of, you know, the circumstances that occurred in terms of, for the purpose of stand your ground, but defining an assault, whether there was a forcible felony involved, I don't think that needs to be addressed here.
All right. Let me address your report on, the pages are not numbered, but I think it's paragraph 18.
My report, sir?
I'm sorry, your report.
Pages are at the top.
Well, on the second part of it, they are. So you did two reports, one in, I think, May, and then one in June or July, right?
On page 9 at the bottom, post-grand jury.
Yes, sir.
Okay.
Okay. So, in other words, after charges were filed in this, or let me back up. Prior to receiving the walkthrough, you rendered certain opinions regarding Mr. Raja's actions, basically the approach, the failure to identify.
Opinions 1 through 4.
Yes.
In my report were issued.
Yes, sir. In
Before
May
I-
1st of
And
2016.
before I viewed the walkthrough.
Right, okay. After the grand jury, you were then provided with the walkthrough.
I'm going to object to that, Your Honor. We're getting into what he would have reviewed for a grand jury.
I'm
It's
just,
confidential. No burden has been met whatsoever about even discussing what he would have reviewed and discussed there in grand jury.
Your Honor, I'm sorry. I'm reading from his report, post-grand
The
jury.
report here, too.
Thank you.
Again, before and after, I don't think we need to talk about the grand jury situation.
All right. Okay, after June 1st of 2016, you were provided a copy of the walkthrough, correct?
The exact date I don't remember, but yes, I was provided the walkthrough post my first report.
And you then opined further after your review of the walkthrough and offered opinion number 5, correct?
That is correct, sir.
And if you look on page 11, which is opinion, I think, paragraph 19F, your opinion was, although Raja states in his walkthrough that he saw Laser Max laser aiming device on Jones' gun was not equipped with such a device, his testimony is not supported by the forensic evidence collected. That's what you said, right?
Correct.
But the photographs that you claim to have seen, in fact, do show a red flickering light around the barrel of that gun, don't they?
Photographs that I'm not sure I have seen that I was told were included in the FBI PowerPoint, or at least some of them were. Okay, so we'll have to clarify it to that. I'm pretty sure I remember a photograph that showed a gun with a glint on it. Okay?
A red glint?
Orange?
Okay. You saw one photograph?
Once again, sir, I do not know how many photographs I saw.
Let's assume for a second then that there's been introduced into this court a number of photographs showing red glint off of the barrel of the gun and a video showing movement of the gun and red glinting off of the barrel of the gun. Let's assume that that's the case.
Objection, Your Honor. This is going to be improper because he's already said he didn't see a video, but he saw photos. So to say that he assumed that he saw it it's a mischaracterization of his testimony and the evidence that's been adduced.
I said assumed that it has been entered into this court.
Assume that it had been entered into evidence. Why don't we you want to show them photos? They're entered into evidence. You
have
want
to.
here? I mean, here's a copy. There's a copy over here.
Showing you Defendant's Exhibit 9, A through K.
Okay, sir. Yes, sir.
Okay. Mr. Richardson, I think he's reviewed the photos.
Okay, thank you. If I may have a moment, Your Honor.
Sure.
Okay, all right. Have you had an opportunity to review those photographs?
I have.
Okay. And do they, in fact, show red glinting off of the barrel of that gun?
Off the cylinder, side of the barrel, underneath the barrel, edges of the barrel.
Okay. So having reviewed those photographs now, would you change that statement where you said his testimony is not supported by the forensic evidence collected?
No, sir, I would not.
All right. You're saying that that has no bearing, those photographs have no bearing on your opinion whatsoever.
Saying I don't think they look like a laser to me.
Okay.
But that's-
Well, that's because you haven't seen the video though, right? You don't think you have?
I've
Okay.
seen these photos.
Okay. One more time, Your Honor. That's all I have, Your Honor. Thank you.
Okay, redirect?
Yes, Your Honor.
Libby, can I have this?
And approach witness, Your Honor.
Sure.
Yes, sir. Did you receive any reports from the defense experts on use of force?
Yes.
Did you receive a report from Dr. Chapman? Do you remember receiving any reports at all from their experts?
I do. I remember seeing Mr. Knox's, Mr. LaForte's. I think these were the depots, not their depots, not their reports.
So you received depositions of their experts?
Correct.
But you didn't receive any reports from them, actually?
Not,
did you?
not to my knowledge, no.
To your knowledge, did they even generate any reports at all?
I don't know. Actually, I heard him say that Mr. Knox said he didn't, and Mr. LaForte said they didn't. So I heard that
They didn't even generate reports?
they didn't generate reports. Yeah. I think Dr. Chapman said he didn't generate a report,
But you actually generated not only one report, but two reports, correct?
as asked by the prosecution.
And defense was questioning you about whether or not you had an opinion on the defendant's use of force. You have an opinion today, correct?
I do.
At the time of your deposition, did you have an opinion?
I quietly in my own mind I did, but I hadn't voiced that opinion.
Had you formulated that opinion before the deposition?
I formulated the opinion after I saw the walkthrough.
But you never actually discussed that with myself or my office until
did
right
not.
before the deposition?
Did not. First time it was mentioned was the day before my deposition when we talked about it.
And so why did you say you felt like a deer in headlights? And Mr. Richardson really didn't give you an opportunity. Why did you say that?
Because I hadn't been asked to opine on the ultimate issue here, which was whether it was justified or unjustified. And in a, it just kind of took me by surprise. I didn't think I was going to be opined on it or asked about it.
But you absolutely had formulated an expert
Absolutely.
opinion prior to that deposition.
I had formed my opinion, yes.
And there was discussion about the defendant having to travel 8 miles up to Donald Ross Road if he was going to come back and get in the generally accepted position behind Corey's vehicle. You remember that?
I do.
Are you aware that North Lake Boulevard is actually only 1 mile south of Palm Beach Gardens Boulevard, that he could have just went south and turned around there?
I'm not aware of that, sir.
You're familiar with I-95 and the many turnarounds that exist within the median that say official use only?
Authorized vehicles only.
So to say that his only option was to actually go 8 miles up to Donald Ross Road, that's not necessarily accurate, is it?
According to what you just told me.
I'm sorry?
What you just said to me. I don't know the area that well enough to opine or to testify as to how to get to that position, whether you have to go north 8 miles, south a mile, use the authorized turn. I just don't know the area that well, sir.
Was there any exigency on an unattended vehicle
None
that would require the defendant to break those generally accepted practices and rush right up there to the front of Corey's car?
None whatsoever.
Is there any evidence to suggest that the only reason why Corey got out of his car is because the defendant approached him?
I'm sure that's the only reason he got out of his car.
And they talked about a fatal funnel. Isn't the fatal funnel that funnel that in this case would be created between the front of the van and the front of Corey's vehicle? I mean, defense is trying to ask you that there's a fatal funnel just by sitting in a vehicle.
It's actually less of a funnel because he's got the van, the engine block in a van usually sits between the front seats. So that engine block is actually in, and he's got a windshield which usually will deflect rounds. I mean, he has a lot more protection where he is. But I have to agree with the defense that if someone gets out of the car, I would get out of the car too and say, please, sir, get back into your car.
And by the phone call, the AT&T phone call, we know that Corey opened his car door,
He
correct?
did. He saw it coming, I think.
But the only reason why there's any evidence that he actually there's no evidence that he jumped out of his car before the defendant got out of his van, other than the defendant's statement.
Correct.
And we know that there's multiple points in that statement that are absolutely just flat out wrong.
Correct.
And so, when the defense says that the defendant would be vulnerable sitting in his van, isn't it equally true that Corey was just, if not more vulnerable, staying in his SUV when the defendant pulled up?
Repeat the question, please.
Defense has said that the defendant is vulnerable if he just stayed in his van.
Right.
But wouldn't Corey be just, if not more vulnerable, to stay in his SUV when that defendant pulled up?
Objection, relevance.
Overruled.
I think that if I saw that van coming at me and an individual dressed as Mr. Raja was dressed, jumped out and rushed towards my vehicle, that I would do one of two things. And I think it supports that he fled. And he got out to do that because you can't flee sitting in your car.
And the question is, though, as vulnerable as the defendant may be in his van, Corey Jones is at least equally vulnerable or sitting in his SUV.
Absolutely. Actually, if we use the same logic that the defense is using, he's more vulnerable because he's sitting in his car.
And he's not the one that aggressively approached the scene.
No, he's broken down.
Overruled.
Is there any evidence, credible evidence, that you found that the defendant identified himself as a law enforcement officer?
No.
Was the victim's reaction in the phone call that you heard, was that indicative of somebody that had just had the defendant announce that he's a law enforcement officer?
No.
He's not a human factors or psychologist expert.
Overruled.
No.
Defense asked you that if a gun is pointed in your face, you have the right to defend yourself for deadly force. You agree with that?
As I said, it depends on the situation. I can't give a absolute answer to that. And I explained. I like to use if a police officer or a person, it doesn't matter, police officer or person assaults somebody, beats them, and that person is down. And then the person that did the beating takes a gun or a knife and throws it down and says, pick it up. And when the person who thinks that's the only way I'm going to defend myself picks up the gun or knife, and that person shoots him and says, justifiable, he had a knife. In fact, under Dr. Chapman's analysis, that would be permissible because it's that point in time, he had a knife. I disagree with that 100%. I think you look at all the facts and circumstances that surround that incident to determine whether it's justifiable or not.
A person and this defendant, what you're saying is, it's not justified in creating the situation.
Correct.
That requires the use of force.
Correct.
And just like any other person, Corey Jones had a right to defend himself.
Yes.
In all of your years of being an officer and managing officers, when a law enforcement officer is yelling at a suspect, show me your effing hands, does he already have his own firearm drawn or is already in the process of drawing it?
Objection, total speculation.
Again, this entire hearing, we have speculated as to what was going on and what was going. I mean, if he can testify under the circumstances, although I'll allow. Let's see what you have to say.
I will tell you that it varies, sir. It isn't always the case, but very often it is the case. As the defense said in their examination of a witness, it's the hands that kill you. And so you want to see the person's hands. I've had fact scenarios that I've reviewed where my officers are pointing their gun at someone saying, let me see your hands, let me see your hands. I've also had facts where they're not pointing a gun and they're saying, let me see your hands, let me see your hands. But they're ready to draw.
Well, there's a difference between walking up to a vehicle stop and saying, can you please put your hands, let me see your hands, and yelling at somebody, show me your effing hands repeatedly.
We have a saying.
Do you agree that there's a difference?
Yes, there is. And I had an academy instructor teach me when I was a baby police officer, and he said that the minute you start using vulgarities and shouting, you've lost control. I think that may have happened here. Show me your fucking hands. Show me your fucking hands. That's
sorry.
shouting.
Overruled, he's giving an opinion.
That's lost control. That's not asking a citizen, please, sir, put your hands on the steering wheel. Let me see.
And it's losing control of a situation that was created by the defendant.
Absolutely.
Is it that the defendant then would have lost control based on a situation created by him?
Yes.
I know that you cannot get in the mind of Corey Jones, but because of the questions asked by the defense, is it reasonable to assume that he believed he was being a victim of assault or some type of crime?
Objection calls for speculation.
I don't know how he can answer that question, Mr. Fernandez. Sustained. I don't know how he can answer it.
I have no further questions, Your Honor.
So I just have a few questions, sir.
Yes, ma'am.
Whether in this situation it was a motor vehicle stop or a citizen encounter or a welfare check or an abandoned vehicle or a potential burglary, in terms of best practices, in all of those situations I just suggested or stated, would the best practice be for the officer's van to pull behind the vehicle?
Yes, it is. And I heard testimony that said he was interrupted in his maneuver. He was going to park in front of the vehicle. But when you think about that, parking in front of a vehicle where someone is in that vehicle and you get out, all you do is you expose yourself to being shot.
But even if you didn't know that somebody was in that vehicle,
still
should you
because
still pull behind the van? or
Your
not?
object is, if it's an abandoned vehicle and you're going to have it towed, okay, your object is to protect property, all right, and to make sure that other people don't hit it, et cetera. So you'd pull behind it, put your flashers on, call for a tow truck, and have it removed, okay? Yes, the answer is behind the vehicle.
So absent any exigency, is there any other time you could imagine where the van would have had to pull in front of Corey Jones' vehicle?
Yeah, if there was a marked police car behind it with its blue lights on, and you were the second officer on scene, no problem, pull in front and you can walk back.
Now, there was also some testimony about, and I don't know if, I can't recall if you're aware of this or not, but about the 911 call that Officer Raja made 33 seconds after the second volley of shots. Are you aware of that? Were you in your review?
Well, I sat here during the testimony.
Okay. And based on the fact that Officer Raja didn't have his radio, can you think of why it would have been 33 seconds after? Can you think of a reason? Why? Any reason?
Yeah, I can, but you're not going to like it.
I'm sorry, can you just talk into the microphone, please, Your Honor?
Yes, I can, but you're not going to like it.
But okay. Is there, okay, so let me rephrase it this way. After a situation such as what occurred here, would it be best police practices to get on your radio or call 911 right away, right after?
Once he discharged his weapon, okay, his next thing is to seek safety, call for backup, set up perimeters, and find out the person, because that person's running away. He said it. He's running away. All right? So he fired the first 3 rounds. Well, get some help. Set up a perimeter. Get the helicopter up with the flare. I mean, there's so many resources available to him, okay? But they weren't taken. That wasn't happening.
Mr. Richardson, any other questions? What about you, Mr. Fernandez?
No, Your Honor.
Okay. All right, thank you so much,
Thank you,
sir.
Your Honor.
Okay. State, call your next witness, please.
Judge, I am recalling CSI Thomas for a couple of questions to introduce one photo, Judge.
Okay. Has the defense seen that photo?
Yes. And actually, Judge, I think that the photo, there's already one in evidence, and I believe it's going to be, is this evidence?
Yes, please.
These comments will affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth.
Okay. Good afternoon again, sir.
Good afternoon.
Judge, may I proceed?
Sure.
Hey, CSI Thomas, I want to go back to when you responded to the scene.
Yes, ma'am.
Okay. Now, you took some photographs, as you testified earlier.
I did.
And some of those photographs included photographs of the gun in this case, correct?
Yes, ma'am.
And that would have been the gun that was owned by Corey Jones, right?
The one collected from stanchion number 7. Correct.
Okay. I'm going to show you what is going to be marked as states. Are we on 5 or 6?
I think 5?
9.
Oh, no, I'm sorry. Okay, I'm going to show you what is marked as states, one from states 9. Do you recognize that photograph?
Yes, ma'am.
Okay, and what is that a photograph of?
Primarily the chrome pistol that was recovered near the street sign and the number 7 stanchion that I put down to mark it for my mapping purposes, and the orange cones that were already in place at the time of my arrival.
Okay, now, the way that it's reflected in this photograph, this was before you touched it at all.
Correct.
And at some point, you did actually touch this gun,
I did.
and you flipped it over to take a photograph of the writing that was on the other side of the gun.
Yes, ma'am.
But the way that it's depicted here in States 9, this is the way it looked when you arrived on scene before it had been touched by anyone.
Correct.
Judge, this time the state we're offering to evidence States 9.
No objection.
States 9 comes into evidence. Can I see it, please, for just a second? Sure, yeah, I just want to take a look at it quickly. There was another photo that was
That's correct. Judge.
similar?
Yes.
Okay,
And
all
what I
right.
want to do with CSI Thomas is to compare what is defense 1H. And now that's the same gun, right?
Same gun.
And that is the gun that's, at this point though, in defense's 1H, the gun has been turned over, correct?
Correct. Myself or my assistant flipped it over for the purposes of exposing the writing on the gun and to view the position of the safety.
Okay, and when you flip it over, it's not buried underneath any sort of like leafy stuff like this. See how it is here?
Correct. That's as it was when I arrived.
So now this is exactly the way it was when you arrived, right?
Yes, ma'am.
And it's actually buried in this grassy area, correct?
It is.
It's buried under this little, I guess this is a weed or something, right?
Some type of vegetation.
Some kind of vegetation. It's buried in there. When you flip it over to take a photograph of it, and now that's before anybody has even touched it.
Since my arrival on the scene, nobody has touched it.
When you flip it over, you just flip it over, take a photograph of the name of it, correct?
Yes, ma'am.
And when you flip it over, it's not buried underneath any sort of vegetation or anything. It's just lying on top of the grass.
Correct.
Judge, that's all I have. Thank you, Mr. Thomas.
You're welcome.
Anything?
Just give me 1 second.
Sure.
No, you're wrong.
Okay, Mr. Thomas, thank you again, sir. Okay, all right,
This time we'll call Dr. Bruce.
okay.
whole truth, and nothing but the truth?
Doctor, good afternoon.
Good afternoon, Your Honor.
You may inquire when you're ready.
Good afternoon, Dr. Juice.
Good afternoon, Counsel.
Can you state your name and spell your last name for us?
My full name is Gertrude Just, last name Juste.
And Dr. Juice, where are you currently employed? Where are you currently employed?
I'm currently employed by the Palm Beach County Medical Examiner's Office.
Okay. And how long have you been with the medical examiner's office?
At the Palm Beach Medical Examiner's Office, I started July 1st, 2008. So it's almost 10 years.
All right. And as a medical examiner, is it your job to perform autopsies?
Correct.
Okay. Now, I want to just jump right in here, okay, the reason that we're here, and that is the autopsy of Corey Jones. Okay, did you perform that autopsy?
Yes.
Okay. And what date did you perform that autopsy of Corey Jones?
The autopsy was performed on October 18, 2015.
Okay. Now, when you are performing an autopsy, are you making notes while the autopsy is being performed?
Yes.
Okay. And the purpose of the autopsy is to do what?
It's to document whatever might be of importance related to the death. It's to make a conclusion as to why that person died and what caused the person's death, and determine the manner of the person's death.
Okay. Now, in this case, did you determine a cause of death?
Yes.
And what was the cause of death?
Gunshot wound of chest.
Okay. And did you determine a manner of death?
Yes.
And what was the manner of death?
Homicide.
Now, as you are going through and performing your autopsy and you're taking notes, are you also, or is somebody else along with you, taking photographs
Yes.
of the body?
Yes.
Okay. Now, as it relates to Corey, how many gunshot wounds did you note?
Corey Jones has one defect caused by a bullet in his chest on the right side. He had 2 holes or 2 defects in the right arm, the upper arm. He also had 2 holes, or more than 2 holes actually, on the left lower arm.
Okay, so before we get into any of that, I have several pictures here, which are going to be states 10A through T as in Tom. And Judge, I've shown them to the defense already.
Okay,
May I approach the-
sure.
I want you to just take a look at these, real quick, and show them to you. Put them up. You recognize that?
Yes.
Recognize that?
Correct.
This?
Yes.
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 That one?
Correct. Yes.
That one?
Yes.
That one?
Yes.
That one?
Yes.
And we need that one?
I don't need it.
Okay, so then we'll make it, S then.
Defense, Mr. Lubin, somebody, I'm sorry, hi. Are you not stipulating to the photos from the ME, or are you stipulating to?
We already did.
Oh, okay. So they're stipulating to them. You still want to show them? It's fine. Okay,
I'll get right into them.
okay.
So,
So you're stipulating? Okay. So this is Exhibit 10.
yes, Judge.
As a
I'm gonna just
composite?
take out what she doesn't, you don't need this?
No.
To explain your testimony? What you said earlier, what about that?
Oh, yes.
Sure.
Okay,
2 of them, that's it.
okay.
You don't need all.
How about that?
10?
This is a larger picture.
Which one?
This is a larger picture. And these 2 are essentially the same picture. So this is, we'll take that.
Okay. We'll Take that one out.
And that one. That one.
You want this one? Mm-hmm. This is okay? Okay. What about this one?
No.
You don't need that one?
No.
Okay. What about this one?
These are the same pictures, but taken side by side.
Okay. Do you need
Not,
testimony?
actually, if you want to take just that one to show that the right one and the left one, we don't need the other ones.
Okay, basically, they're trying to eliminate some of the photos so that they're not duplicative.
Earlier
Okay.
she said she needed them, but now I think she's thought better of it, and maybe she doesn't.
And there's two. That and that. This is one face and
If you
the
want to
other
come up
face.
here, sure, absolutely.
This should be okay. Oops, sorry. Yeah, this shows the two long side by side on one face and on the other face. So we don't need the close-up pictures. No. No, we don't need this.
You need this.
But we don't need that.
You don't need that.
No.
What about that?
It's the same thing, but separate. Pictures are separate. Not really. This and that are the same pictures. See how it blew up of what we saw before. If you want to show that, then you have to show.
Well, I want to show what's everyone else.
We have to show this also. You see, this is the right and the left.
So do you need those?
I don't need them. However, if you want to show the larger pictures, you can take those too.
So keep these in.
That's it.
Okay. And take these out.
We don't need them.
So what we did is we took some of them, okay? And we have to recount them.
Okay, all right. Is everything? Okay. All right. Let's have her taken out, please. Okay, we're going to take a 5-minute recess, everybody.
Okay. This is the exit one on the right arm, so put them in order. This is all left. This is the left. This is his arm. That's it. This is his arm showing the entrance. Do you see what I'm saying?